We will go on the record in the matter 24 CF 169, State of Wisconsin versus Jennifer Rawls. The state appears through Assistant District Attorney, District Attorney Kevin Schmidt in person. We have Ryan Reed, Defense Counsel, in person, as is Ms. Rawls. We're set today for a plea and sentencing. The parties have reached an agreement. Mr. Reed, can you please recite the agreement for the record?
Thank you, Your Honor. District Attorney Schmidt, can you state the offer on the record?
Yes. What the length of it?
14 years, 8 months?
A little bit, yeah, 8 months.
14 years hanging in the balance, nearly $88,000 on the line. One deal stands between a felony conviction and a second chance.
Total of $87,850.94 stipulated restitution.
It's actually 88,000. It's just since she has 1,000 posted.
I know. Yeah, I see that. Okay. And monthly payments of $500. Yep.
So it's the plea to that one charge as is, and then we amend into theft by employees. We do the DJOC on the felony theft, and then convictions on the misdemeanors costs. On the felony, that's the payment plan is described in there. It's $500 a month. It's got a $150 admin fee. It also alternatively lasts until she pays it back, meaning if she can do larger payments, she can get off of it sooner, which is the incentivization.
So she's pleading to be charged as charged, and you're adding two misdemeanor thefts?
Yes. So essentially, she's avoiding the felony if she does pay it back over this long period, and no matter what, she's been convicted of 2 misdemeanors.
All right. But with regards to the misdemeanors, what is the agreement?
The agreement on that would be costs. She doesn't have any AODA issues or something like that to give DOC to deal with, essentially.
All right. Ms. Rawls, is that the agreement that you've reached?
Yes.
Formal motion to amend to add 2 misdemeanor thefts.
So added.
Okay, so it's under $5,000, correct?
Name of it.
I believe it is.
I think it's under.
I think they've changed it so many times.
Excuse me.
Theft in a business owner.
Yep, she's pleading guilty to the charge.
It's under 2,500.
Okay, under 2,500, and we're adding 2 misdemeanors. What's the statute? Do you have that?
Yes, it's just the misdemeanor theft statute. So the penalty provision is 943.23A, and then otherwise the actual statute of the theft is the same as this one, which is 943.20 sub 1 sub B. Oh yeah, I said too fast. Sorry. The statute's the same as the original offense in terms of the charge, which is 943.20 sub 1 sub B, but the penalty provision is where it differs. That is 943.20 sub 3 sub A, which is under 2,500.
And you're simply going to amend on the record. You're not going to do an amended information.
If the court prefer I do the amended information after the hearing, I can do that.
I'm going to say in cases like this, Mr. Schmidt, I'd like that because I've seen a Washburn case that I'm on blow up because they just did it on the record and it got all messed up. And that was from 2013. And so it's hard to piece the cases back together. So if you can do that, I would appreciate that.
Would the court have any problem if I do that after the hearing?
Nope, after the hearing is totally fine. I just want it for connecting the dots in case. Okay, Ms. Rawls, that is the agreement. And your attorney has handed me, well, I have 2 documents. One is a plea questionnaire, waiver of rights form with attached theft by employee, trustee, or Bailey. I should have known you put the jury instructions because you're very thorough. And so I could have told the statute right there. So thank you, Mr. Reed. And he has the jury instructions and the other document that shows the offense and what needs to be proven. Do you recognize these documents?
Yes.
Did your attorney thoroughly go over these documents with you?
Yes.
did he essentially go over them word for word?
Yes.
And so you understand everything on these documents?
Yes.
And with regards to the plea questionnaire, is that your signature on the second page?
Yes.
So your attorney went over with you what the state would need to prove your guilt beyond a reasonable doubt to 2 misdemeanor thefts, correct?
Correct.
And he went over with you the maximum possible penalties you face. Is that correct?
Correct.
Now, I also have the deferred judgment of conviction document with some of the terms, the more important terms were stated on the record. Do you recognize this document?
Yes.
And did your attorney thoroughly go over this with you?
Yes.
Essentially word for word?
Yes.
And so you understand everything completely.
I do.
And that is your signature on the last page.
Yes.
And with regards to the important terms, I'm just going to go over them again with you, that if the court accepts this agreement, that it would run for a period of 14 years and 8 months. Do you understand that?
Yes.
And after today's payment, you would owe $87,850.94. Is that correct?
Correct.
And you're going to make at minimum $500 a month payments, correct?
Correct.
And if they are late, if one of the payment is late, they're due by the 13th of every month. Do you understand that that's enough for the state to ask to revoke the agreement and to sentence you and enter judgment?
Yes.
Also, if you pay it off early, you can have the agreement go away and not worry about that felony anymore. You understand that?
I do.
Do you also understand that within 60 days from today, you must pay $150 to the district attorney's office?
Okay.
If you don't, that's the number one reason I see the district attorney's office asking to have these matters or these revoked and to set you for sentencing. Do you understand that?
I do. Do I pay that where I pay my ticket?
No, you pay that at their office.
Okay.
Okay?
And where's that at?
Very important.
Just on the whole.
Okay.
Very important you do that, and I would do it as quickly as possible.
I get paid Friday, so I'll do it then.
All right. So I have that you're pleading guilty to 2 counts of misdemeanor theft and 1 count as charged, theft of a business setting greater than $10,000 but less than $100,000. Is that correct?
Correct.
You're 39 years old. You have 12 years of school. You can read, write. You understand the English language.
Yes.
You are not currently receiving any treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or medications in the last 24 hours.
Correct.
Because you're charged with crimes, you are entitled to constitutional rights. Each of these rights is listed on both of the documents on the first page. Your attorney thoroughly went over those rights with you,
He did.
and you understand them completely?
I do.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
I do.
That even concerns a deferred judgment of conviction. You understand that?
I do.
Do you understand, or do you need me to go over these rights with you in any more detail?
I do not.
You understand that you're pleading guilty to a felony. If the court accepts the deferred judgment of conviction, this won't be applicable to you if or until the court enters judgment to sentence you. Do you understand that at that time, you would no longer be able to use or possess a firearm for life?
Correct.
You would no longer be able to vote in any election until your civil rights are restored.
Correct.
Those do not apply to the misdemeanor thefts, okay?
Okay.
All right. Do you understand that here, the state would have to prove with regards to the charge that it has been charged, that count 1, theft of a business setting greater than $10,000 but less than $100,000. Do you understand that the state would have to prove on or around and between February 7th, 2023 and July 6th, 2024 in Burnett County, Wisconsin, by virtue of your employment, you having money in your possession greater than $10,000 but not to exceed $100,000, and you retained possession of that money without the owner's consent and with the consent to convert that for your own use. Do you understand that?
I do.
And do you understand the maximum possible penalty if the court enters judgment of a G felony could be up to a $25,000 fine and imprisonment of up to 10 years or both? Do you understand that?
I do.
as to both of the misdemeanor thefts, do you understand for each of the thefts, the state would have to approve, or would have to prove that you had possession of, oh, wrong one, sorry, that you intentionally took and carried away with property of another. You took and carried away that property without the owner's consent. You knew that taking and carrying away that property was without consent, and you took and carried away the property with the intent to permanently deprive the owner of that property. And this is less than $2,500. Do you understand what the state would have to prove?
Yes.
And that's for both counts. You understand that?
Yes.
Do you understand the maximum possible penalty for each of those counts could be a fine of up to $10,000 or imprisonment of up to 9 months or both? Do you understand that?
Yes.
Do you understand that this court is not bound by the agreement reached between the parties?
I do.
Said differently, if I thought that there should be something different for a sentence, I can do that in my discretion. Do you understand that?
I do.
Do you also understand I do not have to accept a deferred judgment of conviction?
I do.
Do you still wish to proceed and enter a guilty plea?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Did you review this criminal complaint with your attorney?
Yes.
In particular, there is a section called the probable cause section, and it basically says what happened throughout that time and why you were charged with the crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Mr. Reed, may the court use the probable cause section of the criminal complaint to find a factual basis?
No objection, Your Honor.
Has anyone made any threats or any promises to you, Ms. Rawls, for you to plead guilty to these crimes?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked at the defense or at the discovery, and has he discussed that with you?
Yes.
Has he discussed with you whether or not you have any defenses or a lack of defenses in this case?
Yes.
Has he discussed with you what could happen if the matter goes to jury?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or your attorney before I proceed?
No, thank you.
Mr. Reed, do you believe that Ms. Rawls is entering her plea freely, intelligently, and voluntarily?
Yes, Your Honor.
Do you believe she understands the rights she's giving up and what that means?
Yes, Your Honor.
Do you believe she fully understands the deferred judgment of conviction and how important it is to meet every single provision?
Yes, Your Honor.
Does she understand the ramifications of what could happen if she does not meet every single provision?
Yes, Your Honor.
14 years hanging in the balance, nearly $88,000 on the line. One deal stands between a felony conviction and a second chance.